Good afternoon, everyone, and welcome to today's advisory session. This is the first in a three-part series provided by Hirschler and OneDigital, where we're going to be reviewing and answering the top questions that we're hearing from employers like you on the FFCRA, leave, PTO, and reasonable accommodations. I want to thank you all for joining us today. My name is Carrie Bartlett, and I'm a benefits specialist here at OneDigital. And today I'm joined by Andy Sherrard and Jamie Weisgarber, partners at Hirschler that specialize in employment law. We also have HR consultants, Stacy Motley and Jessica Singleton from OneDigital. Before we begin today, please note that the session is being recorded. A PowerPoint will be provided with the slides to you after the session, and we'll also be taking Q&A. You'll notice on your screen that you can submit a question in the Q&A. We do ask that you use that instead of the chat feature so that we can track those questions. And if we have time at the end, we may take a few live. We do, of course, have a disclaimer to let you all know that all the information that we're providing today is general information. It is not specific tax, legal, or accounting advice. You'll see disclaimers from OneDigital and Hirschler here. And again, this will be provided to you after the session today. And today we're going to be talking about what employers really need to know around the review of the FFCRA and the leave requirements that are in place, as well as recent updates that have been provided on the FFCRA. We're going to dig into some top questions from employers that we're hearing, as well as talk a little bit about how to support working parents and some considerations that employers need to make. Again, we are going to kick it off with Jess.
Good afternoon. Thanks so much, everybody, for joining. We're so happy to have you. And we know that this has been a very long season. We're approaching the end of the year here, and we wanted to take an opportunity to go through the FFCRA, which stands for Families First Coronavirus Response Act. So to know what the formal name is instead of just the acronym, many of us have encountered issues with this or employees that have needed to utilize this so far throughout the year of 2020, this radical year. And some of us are just now coming upon scenarios that are coming up. So first I want to go through some of the basics, and later throughout the presentation we're going to get into some frequently asked questions as well as some of those fun one-off scenarios. So Families First Coronavirus Response Act includes two new leaves that are new for 2020, the Employer Paid Sick Leave, known as EPSL, and the Emergency Family Medical Leave Expansion Act. So the overview, this kicked in April 1st, and it's going to run through the end of the year through December 31st of 2020. Applies to any employer that has fewer than 500 employees and all public sector employers as well. For employees that are unable to work due to any qualified reasons, there's a list of about 6 of those. You can find them on the Department of Labor website. And it does not apply to furloughed or laid off employees because a work site may be closed due to a government order. That's critical to know, because if you've got employees in that status, and many of us do, this does not apply. It's active employees, and if you have 500 employees or less. There are employer tax credits for this paid leave, daily caps, employer shares of health premiums, and for those employees that do qualify for this leave. If you're an employer that has less than 50 employees, there's a small business exemption, so other things to think through. And employers can include healthcare provider emergency responders as well. Things to think about with the EPSL, or Emergency Paid Sick Leave, are that if you have an employee that's available for 80 hours, up to 10 days for full-time employees, or over a 2-week period for part-time employees. For employees' own need, to government quarantine, or for a healthcare provider that's advised to self-quarantine or experiencing symptoms of COVID-19 and seeking a medical diagnosis. The employer must pay 100% up to $511 a day or $5,110 throughout the 2-week period. And it's also applicable for employers who are caring for another individual due to government quarantine or healthcare provider self-quarantine. And at that point, when you're caring for another individual, that's 2/3 of your regular pay with a cap of $200 a day or $2,000 a week. Additionally, on the emergency paid sick leave, if you're there to care for a son or a daughter whose school or daycare has closed or is no longer offering those services, that's also going to fall under the 2/3 pay up to $200 a day, again with a cap of $2,000 per week. Employer can pay over the limit if you so choose, but the tax credit's going to be capped. So those are some things to think about on the back end. Of course, you've got that flexibility as the employer to go above and beyond should you choose to. Employees cannot be required to use existing paid leave, but they can supplement. So we'll get into many examples, but if an employee is asked to take off because they've been exposed or they've got a positive diagnosis, employers are not able to require them to take their vacation time or PTO. You can say if you want to supplement, then that's an option. And then lastly, the unused leave does not carry over or pay out at termination. Next, the next element is going to be your emergency FMLA expansion. So we've all probably encountered FMLA. That's old hat. We've been doing that forever and ever. And now we've got an emergency expanded FMLA. And that's again for the employer size 500, looking again at all those eligibility criteria we just went through. Employees employed for at least 30 days. So if you're relatively new to the organization, you have to have been employed for at least 30 days. If you're caring for a son or daughter whose school or daycare has closed, this is going to apply. Also, the first 10 days of this expansion of the EFMLA as a 10-day elimination period. So those first 10 days are unpaid. The employer must then pay 2/3 of the regular rate up to a maximum again of $200 per day. And this maximum goes up to $10,000 for up to 10 weeks. Again, you can pay over the limit, but there's going to be a tax credit cap. You can be required to, cannot be required to use existing paid leave again, and employees must elect to use the EPSL on the first 2 weeks of the emergency FMLA expansion. This is a benefit that's going to go up to 12 weeks. It can be reduced by any FMLA that's already been used, again, in that look back of 12 months, similar to the regular FMLA. And your regular job and benefits are protected during current FMLA. And now we're going to go through some updated regulations that just came out this fall.
All right, Andy Sherrod here from the Hirschler team. I'm sure as everyone remembers when the FFCRA first came out, everyone was struggling to figure out exactly what their obligations are, trying to read the tea leaves in terms of what the law required. Then very helpfully, the DOL issued a fulsome set of regulations in April that provided a lot of good guidance and really were the basis for making a lot of decisions about how this FFCRA leave should be applied going forward. Unfortunately, the United States District Court for the Southern District of New York sort of threw a monkey wrench in all of that in August of this year by ruling that portions of the DOL's regulation were invalid. And so that sort of threw into question, how that decision was going to be applied. Did it only apply in New York, for example? Did it apply nationwide? Lots of questions arising from that. And the decision didn't invalidate the entire set of regulations, but only a few specific portions of it. And so in response to that decision, the DOL actually went back and revised the regulation to specifically address the points that the district court had raised in its opinion and had found to be invalid. There are basically 4 areas that the DOL went back and addressed to provide more clarity. And so the new regs went into effect on September 16th of this year. So going forward, employers can rely on those regs again and don't have to be worried about the Southern District decision. So just to summarize what the revisions entail, first of all, and this was a biggie because the court had invalidated the provision that basically says you can't take FFCRA leave if there isn't otherwise work available to you. Basically, the idea is the but-for cause for the leave has to be a COVID-19 related reason. And the court had invalidated that. But the DOL regs go back and affirm that the qualifying reason must be one of the criteria, and it's not simply that there's no work available. So that was a big area of emphasis and a good correction on the part of the DOL there. Secondly, another point of vast confusion, I think, in the Southern District's decision was the court had invalidated the provision that said employers and employees have to agree if intermittent leave is available to be taken. So the new regs go back again and emphasize that agreement is required. So the employee does not simply have a right to take intermittent leave. There has to be an agreement. And we'll talk a little bit about how that plays out in the back to school setting. But helpfully in the revised regulations, they do make it clear that if you've got a hybrid schedule, for example, where the person's child is supposed to go to school Monday, Wednesday, and Friday, but not on Tuesdays and Thursdays, the school is considered closed to those employees and their children on the days that they are not allowed to go. And so that is actually not an intermittent leave scenario according to the new regs. Next, and this one, was really surprising to me when the regs first came out. The DOL basically created a very expansive definition of what a healthcare provider was under the Act. And importantly, they're talking about healthcare providers that can be excluded from taking the leave. And it was a really expansive definition, which basically was keyed off of what the employer's business was, as opposed to what the employee's role was. And so after the district court invalidated that part of the reg, the DOL went back and clarified that the definition really pertains to people who are performing some sort of healthcare function within the organization, not simply the fact that they are employed by the organization. And lastly, they just clarified a little bit in terms of the timing for making the disclosures on information necessary to take leave. The initial regs had talked about that documentation needing to be submitted prior to the leave, and they've clarified that it's really a reasonably practicable standard now. So that's it.
Hi, everybody. I'm Jamie Weisgarver. I'm also with the Hirschler team. And I wanted to talk a little bit about considerations as we get towards the end of the year. As you all probably are aware, the FFCRA is set to expire on December 31st at the end of the year. I think I saw a question pop up on the sidebar, do employers have to allow usage after 12/31 if somebody hasn't exhausted their hours? But the answer is currently no. The law expires at the end of the year. Anybody that's been following the news, I'm sure you guys are aware that there has been talk of expanding FFCRA eligibility. There's been proposed legislation that extends coverage, but at this time, it's really just unclear what's going to happen. So we're all going to have to pay close attention and just keep following the developments as they pop up. Andy mentioned the Southern District of New York case that resulted in some changes made by the Department of Labor. I would encourage employers to sort of frequently check back on the Department of Labor's website. They have some really helpful frequently asked questions pages that are posted, and those get updated when there are regulation changes. For example, when the DOL issued the temporary regulations addressing the New York case. So those are really helpful. I would also encourage employers to just communicate with your employees about the expiration of their rights under the FFCRA. I think communication is going to go a really long way in helping to avoid confusion or disputes that may arise, as we get towards the end of the year. Carrie, I'm going to pass it back to you.
Thanks, Jamie. I know furloughs and terminations or layoffs were really being considered when everything first happened and the FFCRA was passed. We're actually still hearing from employers today that maybe they didn't implement these actions and now they're considering it, and kind of what do they need to know. And just a reminder, for furloughs and terminations, the FFCRA paid leave isn't going to be applicable for employees in that scenario. But there are a few benefits considerations that we did just want to point out. Many of the insurance carriers are allowing employees to stay on the healthcare plan if they are furloughed for a period of time. So keep that in mind. You want to check with the carriers that you work with for your medical insurance coverage. And if you happen to be self-funded, you really want to check with your TPA or stop loss provider to see how that's handled, because if there is a claim that happens, it may not be covered if you haven't had that conversation. Of course, employers can also terminate the healthcare coverage and offer COBRA due to the reduction in hours. And then you want to also check your disability life insurance coverages as well for those contract languages around furloughs and the unpaid leaves of absences, so that you know how to handle it and how to communicate to your employees. For terminations and layoffs, you would have to provide COBRA as a benefit to employees as long as the health plan stays in place. So if, as an employer, if you're actually closing your doors, there are other considerations that you would have to consider if that were to happen. So just a couple of quick reminders on that, because obviously there's a lot to keep up with as an employer, and benefits is just one part on top of all the other legislation that's there.
So guys, we were thinking we'd try to tackle some of the top questions that we've been seeing from a legal perspective and also from an HR perspective. This question is one that I've received a lot. What if an employee is afraid of meeting in a group or refuses to go to work? From a legal perspective, a general fear of COVID-19 is not a qualifying reason for leave under the FFCRA. So if a person is simply refusing to come to work only because they're afraid of catching the virus, that person can be subject to discipline up to and including termination. That being said, the Department of Labor is certainly encouraging employers to be flexible. And I would encourage employers to communicate with your employees. Will providing additional PPE alleviate some concerns? Are there other measures that can be taken in the office to enforce social distancing requirements? In other words, find out what the person's concerns are and see if there's any way to address them. And I think that's going to go a long way in avoiding disputes and getting people back to work safely. I think sending the message that you are concerned about everyone's health and well-being, and doing your best to take measures to keep everybody healthy, that's an important message to send. Stacey, what are your thoughts from an HR standpoint?
Hi, Jamie, I think you're exactly right. So while, yes, technically, legally, employers are covered if they decide that they want to terminate or discipline someone who's refusing to return to work, ideally, and what we're seeing a lot of employers do, a lot of our clients are saying this, we'd want you to work with your employees, have a conversation, find out what their concerns are. Are they refusing to return for a legally protected reason? If they are, if they're having some kind of illness that they're dealing with, whatever it is, then encourage them to apply for some kind of legal protection for that. If it's that they have another concern, can you work with them? Can you be flexible? Maybe extend remote working, potentially allow them to use their own PTO to cover their absence, whatever it is. You can't know how to solve that issue until you have that conversation with your employees. And so that is definitely the route to take.
All right, next question is, what if you have an employee whose his immune system is compromised and has been advised to self-quarantine, or if the employee is experiencing symptoms of COVID-19 and waiting on test results? So to take the first question first, so I think the answer depends whether or not the employee has been advised to self-quarantine by a healthcare provider or not. If the employee has been advised to self-quarantine by a healthcare provider, then the employee is entitled to the leave under the FFCRA. If it's a general sense from the employer that the employee might be susceptible and therefore should self-quarantine, technically that's not a qualifying reason under the Act. For the second one, if the employee is experiencing symptoms of COVID-19 and awaiting test results, that one's pretty clear-cut under the law. Yes, that is one of the qualifying criteria, and so the employee would be eligible for leave during the period where they're waiting for those test results from that are going to verify whether or not they actually have COVID-19 given their symptoms.
Yeah, thanks for that, Andy. And, we've done a lot of research on the CDC website and following best practices, to wait for those results, implementing some of the self-screening questions. If people are experiencing symptoms, may they not already been screened, may they not have a result back yet, but if they are experiencing certain symptoms, to self-report and to err on the side of caution and not come in from a standpoint of potential for exposing others. Each organization is looking at this on a little bit of an individual basis on, how are we operating? What is the business need? What flexibility can we have and do we have? And being, fluid with that. And also there's a rapid test out there. So sometimes, depending on the scenario, we may encourage employees to request a rapid test to see if we can get those results back a little bit faster, see if we can either, return them to work or not. If they're not experiencing any symptoms, that's one thing. But if they are experiencing symptoms, there's the symptoms-based strategy and the test-based strategy that the CDC outlines. Back to part one of this question, if someone's immunocompromised and has been advised to self-quarantine, great point, Andy. Who advised them? Was it a physician? And if so, again, back to old hat on the HR process. If a physician is telling an employee and telling us as the employer that this person, needs to self-quarantine, then we need to remember what is our scope and what is our opinion versus the physician's opinion of this person needing to self-quarantine and following those directives. So being cautious on whether we agree or disagree, if we've got physician documentation and navigating that. And also, again, approaching it with that interactive process. We're going to deep dive into some of these things next week in terms of reasonable accommodation and the interactive process, but starting that dialogue with your employee and what their physician may be advising, what the limitations are, what are their job duties, and whether or not you can accommodate a work from home or remote work, and helping to get creative with some of those solutions, as many of us have encountered so far. So stay tuned next week for more information. And Jamie, I'll let you start on that next question.
Sure. So next question, what if an employee has tested positive for COVID-19 and is either slightly ill or severely ill? I think this one's a little bit easier. You know, this person is clearly experiencing symptoms. I'm assuming they've sought a medical diagnosis since they have a positive test result, and they have presumably been advised by a healthcare provider to self-quarantine. And so under the law, this person is going to be eligible for emergency paid sick leave up to 80 hours for a full-time employee. I would add here, just make sure that as an employer, you are gathering and retaining all of the documentation to be able to claim the tax credit for this leave. That's going to include, in this particular scenario, the name of the employee, the dates for which that person has sought leave, the reason for the leave, a statement that the person is unable to work because of the reason for the leave. And if that person has been told by a doctor to self-quarantine, the name of the healthcare provider that advised that person to do so. Stacy, what have I, anything to add here? What have I said that's wrong? Hopefully nothing.
Yeah, you are correct as usual, Jamie. No worries on that one. The only thing I would add is that ideally you do also want to get a doctor's clearance for them to return. So once they are no longer ill and are able to return to work, getting a doctor's clearance on that. And also just more generally, not specific to COVID, really remembering to encourage your employees when they're not feeling well, whether or not they've tested positive for COVID, just in general, stay home. If you're not feeling well, there's no reason to force your way into the office or whatever work site and risk your own health and the health of others, quite frankly. So definitely encourage your employees to stay home when they're not feeling well. And as Jamie also mentioned, documentation is your best friend. And so we'll go to the next question now. And so this one, what if an employee does not have childcare?
Yeah, so from a legal perspective, childcare is definitely one of the criteria that enables someone to take FFCRA leave. So let's talk a little bit about what that means under the regs. Doesn't necessarily have to be a formal daycare center or licensed childcare provider. It could be grandma. It could be a cousin. It could be a family member or a friend that is regularly taking care of that person's son or daughter. That's a pretty expansive definition. The friends and family category doesn't even have to be compensated for that child care. So if you've got a scenario where either the daycare center is closed due to COVID-19 related reasons, and it does, remember, all of this is always because it's a COVID-19 related reason, not because it's closed for some other purpose. And when we've got a friend, for example, say your friend or family member is your child care provider, and if they're not available, it's got to be because of a COVID-19 related reason, not because they're on vacation. And so if the child care provider is not available, then they are eligible to take the FFCRA leave. One other point legally is that there also has to be no other suitable person available to take care of the child at that point. And so that's something you want to just confirm with your employees. For example, is this a two-parent household where the father or the spouse could be taking care of the child instead of your employee? Or is there another family member that might be able to step in? So that's part of what the regs do allow you to ask, and what they are obligated to confirm, that there's no other suitable person available. Stacy, what else?
So all good points. One thing I would add is just another angle on this question. So yes, you're eligible for leave, but we've also had some employees who don't want to take leave. They just want some flexibility with their work schedule or their work location. And so for that, I would say what we've been saying this whole time, which is flexibility is key. If you can make accommodations in some way for this employee, definitely encourage you to do that, but as well, be consistent in how you apply that. So you want to make sure you're treating everyone the same to avoid any claims of discrimination. And but again, flexibility is key. One thing about flexibility is that it does increase employee loyalty, which then increases employee retention. And that's always the goal, right? So if you can work with your employees, they will work with you. And that's really important.
I'm going to jump in here because we've had some good questions. And one of them, I think that's very specific to this that we've heard, I think a lot of daycares are back open now. What if like an employee's daycare closed because of COVID and maybe never reopened? Or how do you basically get an employee to look for other childcare services if it is going to be an extended closure? Do you have the ability to do that as an employer to kind of push them to find other care?
From a legal perspective, Andy, Jamie?
Well, I mean, I would say, I'd go back to the point I made earlier in that the unavailability of the childcare has to be due to a COVID-related reason. And so if the childcare provider shuts its doors, then I think they need to look for another childcare provider. And it would only be at that point if their next childcare provider closes again because of a COVID outbreak or something like that, that they would then again be eligible for the leave under the law.
And that's definitely great advice. I mean, right now, what COVID's teaching us is we have no control over anything at all. And so things are going to happen. That's going to pop up. I'm going to keep repeating it. Flexibility is key. So if you can work with your employees while they look for alternative childcare, that'd be something that I'm sure they'd be really happy about and grateful for.
All right, so here is a beautiful bar graph. Who else loves data? Am I the only one? Carrie, we got a couple more hands. Fantastic. We wanted to include this chart. Back in, a few months ago, I read a statistic that leaders are spending around 30% of their time to keep up with COVID changes, CDC, all the legality, the numerous things. And I think that 30% is just dramatically understated. In actuality, it's much, much more than that, particularly from folks like us on the HR side and our employment law attorneys and things. It's a significant amount of time. And then for practitioners who are within organizations having to keep up with everything else non-COVID related, let's not forget business shall go on, hopefully, in many scenarios. OneDigital set up what we were calling a coronavirus hub, and we've got a link here, and we will share these slides with you as well. We've answered since April over 5,500 inquiries. The flood of questions were coming in, and we really thought that there's a need for some designated expertise to help answer these, not only for all of our in-house practitioners, but to stay on top of all of the changes. This graph is going to show in the blue bar there, the daily inquiries, and then the orange line, or I'm sorry, the blue bar is the weekly inquiries, and the orange line is the daily inquiries. So back in July, we've got a little bit of a peak. And it starts to taper down a little bit as we get into early August. We see another peak into mid-August as schools started to come back into session, and every school district had a slightly different regulations and practices that they were going to follow, and announcements, and then updates to the FFCRA, and how on earth are we going to navigate this? So we've gotten a ton of questions. We just went through some pretty standard ones, but we also know that many of you out there, and many of you submitted questions ahead, we're going to get through a couple verbatims, the fun one-off or a little more complex, hairy scenarios. How do we navigate these? So Jamie and Stacy, kick us off.
Sure. Okay. So this is a little bit of a tricky one. An employee who was out sick for over a week. He thought he might have COVID, so he went for testing, but it came back negative. But he was out for several days waiting for the results. Does all of that missed time fall under the FFCRA? So I would say, if this person was experiencing symptoms and seeking a medical diagnosis during that time that he was out, then I think legally that missed time does fall under the FFCRA. Where it gets a little trickier is, what if this person, sat around for a few days, then, maybe eventually decided to go get tested, had to wait a few more days before the test came back negative, then you've got a question of that, does the initial time fall under the FFCRA, or did this person, just sort of wait too long to go seek a diagnosis such that that time should not be paid time off? My thought is, rather than get into a dispute with this employee over, whether or not he sought a medical diagnosis quickly enough or, made an appointment quickly enough, I think I'd be inclined to recommend that the employer, count this time as paid sick time under the FFCRA. I think that's probably more in line with the DOL's guidance on this, as Stacy mentioned, being flexible. So that's sort of where I come down on this one, but it is a little trickier. Stacy, what do you think?
I think you gave the perfect HR response. It depends. But I will say that for leave that definitely was not covered by the FFCRA, you still have other options. So if you have another type of leave that's applicable, they can absolutely use that. So they can use their paid time off, the sick leave that you might offer through your company. One thing I will say is that another thing that COVID sparked was a lot of employers reviewing their employee handbooks to make sure that all scenarios are covered. And so this, if you have not done that yet, would be a great time to look at your handbook and make sure that you do account for all of these types of situations. Because again, these aren't all specific to COVID. There are going to be times when your employee gets sick. What options are available to them? They should be clearly stated so that way they can be, again, applied consistently. And so what's our next question?
Well, I have a quick jump in to this, and I think it's relevant going forward too, is as an employer, what kind of documentation can you request? In this scenario, the information came back that they were negative, but even for positives, what information can employers request from an employee?
Yeah, I think the FFCRA, they make it pretty, they try to make it pretty simple for the employee to provide information. It can be in writing or orally. And it's just basic stuff like, your name, the reason why you're seeking leave, the fact that you can't work because of the reason that you're seeking leave. In this particular example, I think the employer could probably fairly request, the doctor's diagnose, the name of the healthcare provider that diagnosed the person, and I think that would be all fair game.
All right, next question. This is a scenario that I've had many clients ask about. So you've got an employee who attends an event, and they later find out that someone who was present at that event tested positive for COVID-19, but the employee is not experiencing any symptoms. So the questions become, should the employer make this employee quarantine? And if so, are they eligible for FFCRA leave? So, this is a gray area and kind of a tricky situation to encounter, and it's very common. In terms of whether the employee should quarantine, I think my primary advice to folks is just to follow the CDC guidance on this. I mean, okay, you were at an event, someone's tested positive. Well, were you within 6 feet of that person for a material period of time where, you could plausibly assume that you have been exposed to the virus? Or was this someone that you saw across the field or a crowded room and never really encountered that person? If it's the latter, you probably don't need to quarantine under the CDC guidance. If it's someone that you were, having a close conversation with and catching up on old times for half an hour, then, you probably have been exposed and probably should quarantine. But then we get to the FFCRA component of all this. And so, if the employer rightly wants this employee to quarantine, because they're afraid of exposing others in their workplace to, positive potentially positive folks, is that one of the criteria under the law? I mean, and really no, because at that point in time, the employee hasn't been directed to self-quarantine by any healthcare provider, and they're not experiencing any symptoms. So remember, the seeking, a test is if you're experiencing symptoms, and the quarantining is if you've been directed to do so by a healthcare provider. So, but I've had a lot of companies that are saying, I don't want this employee in the office. I'd like them to be able to get leave. And so my advice generally has been, yeah, tell them to quarantine, but also tell them to seek medical treatment. And if that employee goes to a doctor and the doctor says, yeah, you've been exposed to someone who had COVID-19 in a close fashion, yes, you should self-quarantine for 14 days. Boom, then they've got their qualifying event under the FFCRA. Jess, anything to add from an HR perspective?
Oh yeah, I love it, Andy. I was just going to challenge you and say, but this person disclosed to me that they were at an event and there's someone there who is positive. Can I make them stay home? I don't feel comfortable having this person in the office around me or my other colleagues. What do I do? And I love how you responded with, have them go get a screen if you're feeling, and what is the level of exposure, proximity? We learned early on that it's, did I have any PPE? Is it within a certain distance and prolonged period of time, defined by around 15 minutes of exposure. And also, I'll just add, I love to travel. I love concerts. I love being out and about. This is hard. And there are so many different levels of comfort around this, particularly generationally speaking, and not knowing what people have going on at home or what else, they're concerned about, their own health issues or exposing other loved ones. We've had quite a few clients come to us and say, listen, I've got this cohort of people who are going out doing whatever and then coming into the office, and it makes many of my other employees uncomfortable. And if you've got a confirmed positive, I go back to some of those initial screening questions that many of you have in place of, are you experiencing any symptoms? Do you have a temperature of 100.4 or higher? Have you been around a confirmed COVID positive person within the last 14 days? So if you're asking your employees to attest to those or fill out some sort of form before they come into the workplace, this may be one of those boxes. And again, I'm in full support of seeking medical direction, because it's not really for us as HR practitioners to determine whether someone, what the risk level is. So go get the test if at all possible. Encourage your employees to be mindful, take precautions, be considerate of others. Also educating your team on all the precautions that you've taken in terms of increased cleaning, social distancing at the office, masking in and out of an office or common areas, maybe changing some of the break room practices, what food services you may offer or not. A lot of employers have changed those things. So if I'm out at an event and I was exposed and I disclose that, I also think it's a case-by-case basis. So sometimes we really want if this, then that answer, but we need to be cautious about making blanket statements and taking in all of the details into each scenario and responding accordingly.
All right, are we back to school now? So just some considerations to talk about, as everybody's getting back to school here. If the school is physically closed, even if it's providing online learning, then employees are eligible for FFCRA leave. If the school is physically open, but the parent employee chooses to send their kids virtually to attend online, then that person is not eligible for FFCRA leave. So it really sort of hinges upon whether or not the school is physically closed, school or daycare is physically closed. Also, I believe Andy or Jess mentioned this earlier, that you're only eligible for FFCRA leave if there's no other suitable person available to care for the child. So that's an important question to ask as well. If you've got an employee whose child has an alternate day or some sort of hybrid attendance schedule, each day of the school closure is considered a separate reason for leave. It's not considered to be intermittent leave. And so the employee is permitted to take FFCRA leave on the days that the school or daycare is closed, and the employee does not have to get the employer's permission to do so, and contrast that with, sort of your more typical intermittent leave. Let's see. That's all I've got on that one.
Yeah, I mean, I think from an HR perspective, I know we've definitely hit home flexibility, but certainly all employers have working parents of school age kids, and so it is something that I think that, as employers, you need to continue to look at how you're supporting those parents, like during these times. Obviously, you have businesses and organizations to run, but it's also indicative of your culture. And so if you're looking at how you're coming out of the pandemic, because I like to be positive and we are coming out of this, I don't know how long it's going to take, but we're definitely going to come out on the other side. When you're looking to recruit and retain employees, your culture is very important, and how you're handling this situation definitely comes up. A lot of times your industry is also going to really dictate how you're able to support working parents too. You may physically have to be at your job. You may not have telework options available or as much flexibility as other industries. So just continue to have conversations with your management team too, the folks that are managing the day-to-day employees. That's really important for them to know that they have the support from HR and the executive leadership team in helping the employees that are on the front line doing the work really feel like they've got that support. Additionally, we're going into flu season. And so a lot of the symptoms that we're seeing, it is again about communication and helping employees know how they can handle these situations. And there may be more school closures going into the winter, unfortunately. And so the quicker you can figure out how you can keep your employees working, I think you're going to come out on the other end much better. Did I miss anything? All right. So we've highlighted a lot of information today. Again, these are all questions that we feel like we've been hearing from employers just like you. The key takeaways from our session today is really to understand what those qualifying reasons are for leave because of COVID-19, how to handle those school closings, along with monitoring the DOL updates. As those become available, if anything changes, we'll obviously be communicating with you all as well. Tracking the FFCRA paid leave and retaining that documentation for the tax credits. Keep that in mind. Unfortunately, those tax credits aren't available to local governments and public school systems, but for anyone that's not in that category, you want to make sure that you've got the tracking mechanisms for that set up. The FFCRA right now does end on December 31st. So as we've talked about, making sure that you're communicating that to employees. And as we've mentioned, managing those employees does require more flexibility than ever before. It's making us all be a lot more nimble and learn things that we weren't expecting. But hopefully this session has helped you all kind of refresh on everything that you need to be mindful of. We've got a lot of resources available to you. I'm going to let Jamie or Andy talk a little bit about those resources from Hirschler.
Sure. First and foremost, I just encourage everybody to go to our website, and we've got a COVID-19 resource center like many firms do. I think ours has a lot of good content, if I do say so myself. We've got all the relevant articles pertaining to this topic listed here on the slides. And if you go to the link that's shown at the bottom, they will all pull up for you, but it's everything from just basic nuts and bolts of the FFCRA to discussion of the original regs to a blog post about the recent changes.
Great. And then OneDigital also has a lot of resources between checklists and templates, flyers, videos. I've also included a link to all of our other webinar recordings that we've had. I know there's no shortage of information out there for you, but sometimes when you're trying to find that information, it is helpful to know where to look, as well as a link to our coronavirus hub. Again, we will be sharing these slides at the end of the presentation, so you will have the link to the email address that you can actually email the HR team with any questions, whether you're a client today or not. That's available to anyone. And just a little preview.
I'll give a really small shout out to my colleagues. At the end, you'll see a couple links to those webinars. Carrie did a phenomenal webinar on supporting working parents, and Stacy did another phenomenal webinar on diversity, equity, and inclusion. And I just want to congratulate you ladies for stepping up and sharing that valuable information.
Of course. And we're going to be sharing some more information next week, next Tuesday at 2 o'clock. And we'll include a link to register for that in case you haven't gotten that. We'll be talking about absence and leave management, as well as how that ties into FMLA and how it really all works together. As you know, we're dealing with FFCRA, but all of this kind of starts to work all together, and it can be a little confusing. So we're going to be clarifying that as well. Now we've got some time for Q&A, so I wanted to make sure that we highlighted some of the questions that we received today. The Q&A box has been hot, and so there have been some really good ones here that I want to make sure that we hit. So one, I know that we've talked about already a little bit, but we may want to clarify some. What for FFCRA, does it apply if a child's school has given parents the option of in-person, hybrid, or virtual? And in conjunction with that, there was another question asking about transportation to the school. So like if a parent wasn't comfortable with a child riding the school bus and they need a little time to do drop off for the child. Anybody want to take that one?
Yeah, Carrie, I think it really, like I said, it hinges upon whether or not the school is physically closed. So if the school is open, but the parent has just selected for their child to remain virtual, that is not going to entitle that person to FFCRA leave. Alternatively, if it's a hybrid schedule where the school is physically closed on Tuesdays and Thursdays, but you go in person on Mondays and Wednesdays, then the parent can take FFCRA leave on the days that the school is physically closed.
Great, thank you.
And I'll just jump in quickly on the transportation question.
Yeah.
I would say my answer to that would be no, because the law is really granting leave in the event that the school is closed due to COVID-19. And so the school is actually open if you're transporting your child to school. So I don't think that would be a FFCRA qualifying event.
I would throw out the HR perspective, that flexibility that we keep mentioning. If someone needs a little extra time in the morning to drop off kids, if they take a shorter lunch or work a little extra in the evening, again, you want to keep your working parents, if they're a great employee and they're doing what they need to do, you don't want to be so inflexible that they're not able to, navigate this like everyone else. Stacy or Jess?
Yeah, I definitely want to add in there, thinking about what's the right thing to do and what can we do from a business operations standpoint. I always understand that, hey, we've got to meet business needs. The ship has to keep sailing. I get it. I totally get it. And at the same time, how can we change our thinking? So our world has been changed. The way we used to think, the way we used to operate, the 8 to 5, if anyone had that, is very, very much changed. And so how can we adapt? I think that's going to come out huge for employers in terms of the war on talent that we were facing pre-COVID and are still facing in many industries and many jobs. but what's the right thing to do? What can you do as an employer? And I want to encourage folks to think about a performance-based or an output-based approach rather than so much a time-based approach. So can we offer, again, that flexibility? I'm going to say that word of when does work get done? Is the quality still there? Is the response time still there? Are expectations still being met? And can that be done at a variety of times to help accommodate some of these changes that all of us are battling?
And I'll just add one thing quickly, in addition to the flexibility, which we're going to keep mentioning, consistency is key. So yes, be flexible, but be consistent with how you're flexible and who you're flexible with. It has to be the same across the board if you want to keep yourself protected.
Stacy, that almost sounds a little bit legal.
They come together, don't they? That's why we're here together.
Yeah. Andy and Jamie, here's one, I think from a legal perspective, the question is, how often do we need to remind employees of their rights under the new laws? This particular person said we've sent out the information through the email when they were first established. It's also been posted in their return to the office playbook, and they have postings on their compliance board. Do they need to do more or send out continuous reminders? This employer sounds like they've got it in a lot of places, so it sounds good so far, but I'm curious your thoughts.
Yeah, when you were first asking the question, the first thing that came to mind was the poster requirement. But like you said, it sounds like this employer has gone above and beyond. To my knowledge, there's no requirement to send out constant reminders. I think if you've met the posting requirements and you've circulated it internally and posted it on your intranet, I think you're pretty well covered there. Andy, do you disagree with me?
No, I agree. I think, you meet your legal obligations by using the DOL poster and all that. I think, where it comes together from a legal and HR perspective is, the more communication, the better to a degree, because if your employees are aware of their rights, then you probably will minimize the possibility of them coming back and saying, well, I didn't realize I could have done this, and now I want something that I might not be entitled to anymore, which can lead to headaches and potential claims. So communication continuously is good, but you don't need to over communicate.
Yeah, what is it that Peter Drucker said? It takes 7 times to communicate to someone before they fully understand, hear, comprehend. Someone's going to have to fact check me on that quote.
Well, that actually goes a little bit, Andy, you started to hit on it. Another question we have is, what if an employer suspects abuse? So they have a specific example that the employee is aware of the emergency paid sick leave, and they've been denied work from home. I'm assuming, that position maybe isn't eligible for that. But then they come back the next week and state that they were exposed over the weekend at a wedding. So it sounds like it's coming up again and again. What kind of documentation are they looking for? Should they just let it go? How do you manage that as an employer when you might have a population of folks that like to take advantage of things?
Right, and it's a little tricky because I think the Congress and the DOL in creating the regs really had the mindset of providing the most coverage and the most flexibility to employees as possible. So there are pretty minimal informational requirements, but certainly you can ask for the information that you're entitled to. And so, and if you think that someone is abusing, the act, then hold their feet to the fire in terms of what you're entitled to. I mean, why do you need the leave? What's the reason? If it's, who's the healthcare provider that's directed you to self-quarantine? If there's none, then there's not an entitlement to leave. Make sure that they give you the information that you're entitled to. And if they can't, and there becomes, evident that they are abusing the process, then they can be subject to discipline. Now, it's always a dicey proposition because the law also has, the requirement that you can't sort of, retaliate against someone for taking the leave. And so if someone's asking for it and then you discipline them, then you're in that sort of close proximity in time that no one wants to be in. But if you've built up your record by asking for the documentation, they haven't been able to provide it, and you feel like you've got some objective evidence that they're abusing the process, then I think discipline's appropriate then.
And I'm going to jump in here with one thought as well from an HR perspective. So all of what Andy said is completely correct. But one thing I will touch on, which Carrie mentioned earlier, would be culture. So if you are concerned that your employee might be taking advantage of this act or they're not telling the truth, one question to ask yourself is, why would my employees feel like they need to lie about this versus just telling me the truth? That might be a time when you do a little self-examination and think about your company culture and whether or not you have an environment where your employees feel like they can come to you and share what's really going on with them. Different angle on that question.
I like it. Well,
Okay.
we are right at the end of the hour, and so I would like to thank Andy, Jamie, Stacy, and Jess so much for sharing your insights today. I feel like I'm a student of this and I'm always learning something new. So I know our audience really got a lot of takeaways from today. And thank you all for joining us. We hope that we've been able to provide some of that helpful information, actionable advice. And remember, if you have any questions, feel free to connect with us. Again, the follow-up to this will have all of our contact information included in case you have questions, need some additional help. And we are looking forward to seeing you all next Tuesday at 2 o'clock for our next session. Again, thanks so much, and you all have a wonderful day.